Debra Adimey versus Station Casinos LLC, A850394. Good morning.
Scott Mahoney for the defendant.
Kimberley Weber for plaintiffs.
All right, good morning.
I believe Ms. D'Aquila is on Zoom.
Okay, and Ms. D'Aquila, if you could state your appearance, is she also co-counsel with you? Okay. Oh, you're muted, so if you can unmute yourself. I can see your lips moving, but I can't see you talking. So why don't we just say this? We'll just enter your appearance per Mr. Mahoney as co-counsel. And then do you also have other co-counsel with you as well?
No, I think there may be at least one client representative on, but
okay. All right, great.
And this is my paralegal.
Okay, all right, great, thank you. And then on behalf of Debra Adimey et al., do you have any other co-counsel that is making any appearance?
No, Your
No? Okay, all right, great. So I wanted to kind of start by just discussing, so there were the two initial briefs by, the opposing, one by defense, one by plaintiff. I noted that in the plaintiffs that it touched on discovery issues, but it's not really a full discovery motion. And so I don't know if you're asking me to kind of give an advisory opinion on that. Like, I'm not really sure exactly what you want on those issues. I mean, I think I can probably say, in making my decisions on the issues as far as what could come into play, but it seems like that would probably be more appropriate in an actual discovery motion, which I will take the discovery, so you don't have to go through the discovery commissioner. So that way, not only would it be consistent, but also quicker. So I don't know how you want me to handle those issues. So let me ask you that first.
Yes, Your Honor, we fully understand that this is a unique posture that we have brought before you. The truth is that the party's discovery the documentary discovery has come to a halt. So,
okay.
Because we have disparate understandings of what SB 386 means and what the obligations are under the law.
Okay.
And so if Your Honor is willing to weigh into the legal interpretation of SB 386, the parties will certainly take that into consideration. We have been able to work out understandings and agreements where we can come to an agreement on the issues. We just are so far apart on the SB 386 legal issues and interpretations that we have essentially come to a halt on the documents. But if Your Honor is not willing at this time to
I can tell you how I could see how things could potentially be relevant in terms of, like, for example, when you're talking about similar employment, right? I have no idea how the entities classify their employment. So for example, in the county, you have a schedule. So if you're schedule 23, you're paid the same. If you're schedule 24, you're paid the same. But even within the schedule 23s, there are different types of job descriptions. So I have no idea what it is and how the classifications are done within the casinos. So I'm not really sure exactly what's been produced, what hasn't been produced. So I probably need a little bit more information on that. That would probably be more appropriate in a discovery motion, but I can certainly give you my thoughts on what I think could potentially be relevant. Would both sides like me to do that?
Yes, sir.
Yeah, I think that would be, I think resolving the legal issues will straighten out
Help that out. Okay.
Issues, but we welcome the court's initiative.
Okay. All right. Okay. Well, so why don't we go through those issues then? All right. So first, I guess we've got the meaning of qualified. And so in looking at well, I'll start with the easy stuff. So it seems that you both agree that full-time employees have no greater rights under Section 22. So I think that we can come to an agreement on. So, and then we've got the defendant's position, that it would be the classification time as opposed to time in working at the, I'll just say casino itself, that would be controlling in qualified. So when I look at the AB, is it, no, SB, sorry, SB 386, is it 386? Sorry, okay, see, SB 386, you know, it doesn't really give a distinction as far as the time that they were in that classified position. It really just says length of service means total for all periods of time during which an employee has been in active service, including periods of time during which the employee was on leave or on vacation. While I understand the defendant's persuasive arguments that it would make more sense to have it during the classified, meaning they were at this certain position for a longer period of time than another employee that wasn't, but maybe had been at the casino for a lengthy period of time. I also see merit in the plaintiff's argument that that they are prioritizing loyalty to the casino itself by working there for a long period of time, even though within that time period they may have been at the at that position for a shorter period of time. In looking at the SB 386, I don't see that it makes a distinction regarding the classification. It just speaks to the time. So I would be inclined to find that the qualified just goes to the length of time that that person is at the casino, working at the casino. And you know what, I would think it might be easier if we break down the arguments just according to like the different questions that are being addressed. So that way you don't have to address them all at the same time, and you can be a little bit more focused on that actual argument. So I don't know, you both have briefs on this issue. I don't know who would like to argue first or take the lead on this. Okay, so yes, go ahead.
Yeah, in terms of what does greatest length of seniority, SB 386, as your honor has found, refers only to greatest length of service for the covered enterprise. The cleanest way to interpret that and consistent with the legislative history, as plaintiffs have argued in their brief, is that it should be what we sometimes refer to as property seniority as opposed to classification seniority. There's simply no mention or markings of classification seniority in the text. Defendants seem to argue that first they could use a tiebreaker of classification seniority and a second tiebreaker for property seniority, and that's just simply nowhere in SB 386.
All right, thank you. Mr. Mahoney.
So I'm not going to tell you that there's not some support in the language of the statute for Ms. Weber's position.
Right.
We've cited that.
Sure,
acknowledged that in the
absolutely.
brief, but
Yes.
when you look at the practicalities of it, I mean, what SB 386 is about is it's one about bringing people back to work. It's hiring statute. And secondly, it's they use the word in section 0.10 about honoring the employers, honoring the employees, the former employees' right to return to the same job. So if you're talking about the same job, I mean, part of that's easy. I mean, if you were a cook in the main kitchen or something, part of that right is certainly to return as a main kitchen cook. That part's easy. But we think it also encompasses the right to return to the same job in the order that you would normally have been returned. And we talk about a lot about in the briefing about you know, the bartender example, and you know, someone's been a bartender for 20 years and someone's been a bartender for only 2 years, but they've
Been there for 23 years or however long.
they're in
Right,
some other position for 19 years. So if you look at the property date,
right.
Strictly at the property date without any context, then, you know, Ms. Weber's position would be correct. However, when you.
So let me ask you this. Let me just play devil's advocate for a minute. So under the AB 386, if you had hired, for example, a bartender that had been there as a bartender for 20 years, instead of a employee who had been at the property for 23 years, but had been a bartender for only 3 years. If you had given preference to that bartender who had been a bartender for 20 years, wouldn't that portion of that be covered under, hang on, the part where you would be giving notice to the bartender that had only been a bartender for 3 years, when you give notice to them, hang on, as to, I think it's like, the reasons why they were not qualified, right? Wouldn't that cover that portion of it? That's my question. I mean, I realize I'm playing devil's advocate on that, but that's really more my question as far as, instead of building in a definition that covers the time at a certain job, if you did hire bartender A back instead of bartender B, wouldn't you have been covered under that portion of the statute?
No, we're not saying that the 2-year bartender is not necessarily unqualified position. We're just saying that when you say restoring someone to their former positions, that means restoring them to a bartender position, plus in the normal order of seniority, because and all the employees understand this. I mean, there's no employee there. I mean, in the normal course, forget SB 386 for a minute. In the normal course, if someone, transfers from being a dealer after 19 years to bartender, they don't go in with the expectation that as soon as there's a shift bid, they'll be the first one to bid on a shift, for example.
Right.
They come in with the expectation that I've changed my job. I had a ton of seniority as a dealer, but now I've changed my job. I got to go to the back of the line and wait for certain things. And if you're,
I guess my second question, part of this, I guess, would also be, instead of on the front end making the determination, would this also not be a defense under subsection, oh gosh, what is this? Section 24(3) about rebutting this presumption that it would be a legitimate business reason that you could assert that as a defense, as opposed to having me make the initial interpretation that it covers it under that way?
well, 24B deals only with retaliation, so I don't think
Okay.
24 applies at all to this scenario. I think pretty much everything we're talking about today is in section 22.
Okay.
So, I mean, just to conclude, I think to restore someone to their former job means restoring them to the same job in the order that they expected to be returned. I mean, someone who's been the bartender there for their entire career expects to return as a bartender faster than someone who's only been there 2 years, even though. So I think I mean, there is more than one interpretation of this particular issue, but I think in sorting out which interpretation to follow, I think our position is more in line with the intent of the statute.
All right. Thank you. Anything else?
As Your Honor has heard, I think there are 2 embedded reasons why defendants offer the classification. One is that the classification seniority, the person with higher classification seniority is more qualified. There's no concept of more qualified under SB 386. As a defendant said, if they were hired as a bartender, they're qualified to be a bartender, even if they've only been in that position for 2 years. The second reason is what employees expect in usual business. Again, SB 386 was not business as usual. It was a law that required certain practices with regard to returning employees to work.
Okay. All right.
The
So,
only thing, other thing I'd
yes,
say
go
is
ahead.
in response, it was certainly not business as usual, but I think there were still expectations on the part of employees of how things were supposed to work. And
Sure.
that would be that if I've been there 20 years as a bartender, then I'm expecting when there's a job opening, if there's a job opening, I'm gonna get it before the guy who's been there 2 years, because that's
well,
wasn't
this-
business as usual, but not everything changed just because of SB
All
386.
right, thank you. So, and, you know, I know this is, I'm assuming this is the only case of this nature right now that we've got going.
That's correct. My knowledge.
Unfortunately for me.
Yeah.
But you know, I really think I need to stick to the plain reading. So I appreciate the argument on that issue, but I think the plain reading is just plain length of service at the covered entity. And then let's see, as far as the order of preference. I think we talked about already the full-time employees don't have any greater rates than part-time employees.
We're in agreement.
Okay, and then
So
let's
number
see.
one, I think we might be in agreement on, Your Honors. I understand their briefing on the qualified, to be qualified. It has nothing to do with merit. Doesn't matter if you're the worst employee there or about to
Right.
be fired before COVID or
Right.
employee of the year. It has nothing to do with any of that. So it's just about the same position or similar position. And I think Ms. Weber agrees with that. She'll tell me if she doesn't, but I think, and again, this goes more into the discovery issue, but I think.
So, and you know, let
once-
me,
Once you make a determination,
Sure.
I think that the only qualification is same or similar, then you don't, then the need for all this discovery drops because, for the most part, because I mean, personnel files are all about qualifications, employee reviews, discipline, accommodations,
well, I guess
customer complaints.
so I guess the question for me is, and I'm not saying that this necessarily happened, you know, I don't have all the facts, but if, for example, the covered entity, filled a position with someone who they're alleging was less qualified, is that not part of what they would be showing as far as their qualifications in the employee file?
Well, it's all based on seniority and whether they hold the same or similar position, first the same position. So, I mean, I'm sure my clients would have loved to have made merit-based decisions. They would have loved to.
And I'm not
They
saying
could-
merit,
But they couldn't. I mean, the only thing that an employment file would verify on same or similar would be that, yes, they held the same, because there's something in the file that shows, yes, they were a cook before, so they can come back as the same employee. Or there's something in the file that says, they were a cook's helper before, so maybe that's similar, depending on how that's defined. But, you know, all this extraneous paper in the files don't go to qualifications, because it's all about same or similar.
well, so I don't know if I necessarily fully agree with you on that, and I see you standing up, yes.
Yeah,
And like I said, this is something that probably will be more fully fleshed out in an actual motion, but I mean, to the
Right.
extent that whatever it is that you would like my thoughts on it, I'll certainly give you the thoughts on it.
right, in terms of defendant's first question regarding qualification, it does seem that the parties are in general agreement over the definition of qualified and
Right.
how it applies under the law. The disagreement, as this has bled into, is that they're using that definition to deny the plaintiff's request for personnel records. Plaintiffs do believe that there could be significant information in there regarding what are similar roles. As defense counsel already stated, there could be prior work history. There could also be trainings if they had food safety handling, had similar training, similar requirements in terms of the actual content of their jobs that might be contained in their personnel records that can help us understand which jobs were similar and how they were similar.
Let me ask this though, again, playing devil's advocate, you know, if, and I don't know how the covered entities do this, if there is a open position, for example, is there a job description that is sent out with what the required trainings are and things like that to qualify for that job?
Yes, there should be a job description for every position. And if it's, I mean, if you're looking to describe the duties of a job, the job
Right.
descriptions should have all that, and you don't need to, go through thousands and thousands of pages of personnel files to find the job descriptions.
Okay, so have the job descriptions been produced?
And I will say that we could, in theory, come to a agreement if we could get work history and job descriptions for everyone that could satisfy the bulk of the information that we need, and then we could see if there's any of the retaliation plaintiffs that we might need additional information. But those are only 3 as opposed to.
Okay.
I think now we're talking about the discovery aspects of it.
Yeah.
A little bit, yeah. I mean, a little bit.
Commentary.
I mean, this is again, I'm not making a true ruling, but to the extent that it might assist the parties in moving forward and narrowing the issues for any discovery requests, I would certainly,
I mean, I can certainly, after this hearing at some point, talk to Ms. Weber about producing the job descriptions. A few other things like that.
Right. Because I think the issue is, I mean, and this is for me during trial, how am I supposed to decide what's similar? Right? If I don't know what the job descriptions are and what's similar between the job descriptions and the pay and the duties and the qualifications and things like that.
Well, I might have a solution to that.
Okay.
So I think on number 1, as far as the legal issue, I think everyone's in agreement. Then the court will find that qualification consists of either being in the same or similar position and not performance related issues then.
Correct.
Okay.
Right. I would agree that it's not performance related, but then, same is easier. Similar, not as easy, because then, and truthfully, I know that the legislature was under the gun and like getting this, so they didn't really give all the aspects of what they probably would have been helpful to everyone. But, no criticism of the legislature, but I think in order for me to make a determination at trial, I need some facts from which I can make a determination. Is this similar? Is this not similar? Or there are certain jobs that are more similar to each other than other jobs, right? So that kind of a thing.
Yeah, I understand that completely. The solution that I talked about, I think, is in what we call question number 2, I guess, the corresponding order. And our understanding of that particular portion of
the order of preference.
Order of preference, yes. Our understanding of that particular subsection, I think, clear language, that particular subsection is that first when positions become available, first you have to exhaust all the same positions for example, if there's 40 bartenders, only when you get to the offer on number 40, and then there's 41 comes up, do you get into similar? In other words, first you exhaust the same, and then if you exhaust them all, then you get to similar.
Right.
So the reason I think that the court may be able to avoid dealing with a similar issue, perhaps for the entire case, is that would mean that you have to. The only time similar becomes relevant is if you can find a job category that fully exhausts the same, so you can get into the similar. For example, we gave the example when we were providing the court with some examples of the discovery we've provided, which we think leads to clear answers. So we talked about the Green Valley Ranch cater banquet services.
Well, and here's the other thing too. I was sorry, I don't mean to interrupt, but I just, before I lose this thought, I wanted to say it. It occurs to me that providing some of this information may actually also narrow the issues and also the plaintiffs, because it may be an issue where once they look at some of that information, to one of the plaintiffs, they may be able to say like, sorry, you don't really have a valid claim under AB 386. So, I mean, sorry, SB 386. So that actually also might help both of the parties as far as narrowing not just the issues, but also the claimants.
Yes, that's definitely part of all this. So with the cater banquet server position at Green Valley Ranch, for example, as we point out in one of the briefs,
Right.
you had 6 people who were hired in this position. Same. The first plaintiff, Mr. Alexia, was number 8. So you would have to exhaust through Alexia all the way down through all the plaintiffs, and only then, which point was never reached, then you would have to determine, okay, this person gets what we run out of same, and now what's similar, and there could be an issue about that. But until you reach the point where you have to get to similar, you don't have to worry about what jobs are similar. I mean,
That may be,
and I
I guess it
I'm not sure that Any
depends.
positions where they exhausted the entire list the same.
But we would need the information to really be able to get to that point.
Well, I think she has that information, but I mean, we've had group meetings before about settlement and explaining things. We can certainly have another one, but I think before we worry about doing all kinds of discovery on similar, do we even get to that point? Because if the court agrees with us on the legal interpretation, I think even the plaintiff agrees with our position on that, that you have to exhaust the same before you get to similar. If that's true, and you never get to similar because not all the positions got to the bottom of the same list, then you don't have to worry about it, which is kind of nice.
Okay. What's the plaintiff's position?
Your Honor, I thought that we did agree on this, but with the example of the banquet server, I see we do have some disagreement. So we would agree that if there is a bartender or a banquet server position, that you offer all of those vacant positions first to people that were in that same classification.
Right.
first.
So bartenders go to bartenders.
Yeah.
Banquet servers go to banquet servers. Right.
And then if you run out of everyone in, in that position, then you stop offering. Then you can, once you exhaust everyone, then you can go to similar. I think one of the pieces of disagreement that we have here is that for banquet servers, for example, they claim that they only recalled 6 out of 47 previous banquet servers. But it is our understanding that there were other similar jobs that could have been offered to those remaining 41 people who were never called as banquet servers, that could have been similar food server positions or busser or runner or something positions. And it is our position that those positions, if they had already run through their same,
they should have offered them similar.
Should have been offered to plaintiffs who were waiting for similar work, if they could not get their same work.
Right. So I think there's 2 different situations that we're talking about. From the defense side, I would agree with you that as far as the offering of the work, right, if you go through all of the same positions and there's nothing else left to fill, or actually there's no other, for example, banquet servers, right, that are available. Right. And that want that spot, that exhausts it for that portion of it. But if there are still, let's say 15 banquet servers that are without a job, then I do think the similar point does then kick in as far as what should have been offered to them for similar positions, and what I don't know what would be a similar position to a banquet server. Would it be a pool runner for food? Would it be like, I don't know those things. So if we are talking, I have no idea all the different types of jobs that we are talking about in this case, right? So there may be 4 main jobs that we're talking about, or there may be 15, I don't know. But I think as to whatever, let's say we've got bartender, room service attendant, and banquet servers. Let's say those are all the plaintiffs that's the jobs that they held. I think what would be similar to those three different job descriptions would be relevant in producing the other job descriptions of similar types of jobs to those three types of positions.
So,
I hope I made sense.
yeah, I understand, but, so the problem is, so with the banquet servers, let's, whether they agree on the data or not, I'll leave that open, but, you know, our position is, only 6 banquet servers were returned at Green Valley Ranch. If there was another position, it would go to employee number 7. If there was another position after that, that should have been offered to plaintiff Alexia, but we never got down that far.
Right.
So
But
you
then-
can't,
but
but you
the-
can't say for plaintiff Alexia, I'm sorry, we never got that down that far. But your job is similar, let's say, to a room service person. I'm not sure that's really true, but we'll just say that. That would be unfair to the room service people because you have to exhaust all the room service people before you even consider. I mean, Mr. Alexia.
So right now, we're not, yeah, so, but right now we're not talking really about the merits of the issue, is more in the discovery part of it. So I think in order for the information to be organized, it would be helpful if we could figure out from the plaintiffs which positions how many job description positions that we're actually talking about, right? And then from that, from the defense side, what job descriptions are similar to those, and it may be something where you look at pay, the types of service, like the types of responsibilities that they have, historically, what has been offered to someone in a similar position, pre-COVID, post-COVID, that kind of a thing. And then have those jobs descriptions produced so that way we can actually take a look at, because there may be a job description, for example, there's a bartender, right? There may be other jobs that are more similar to bartender and less similar to bartender. And getting down to the offering room service to a banquet server, that's a issue for a different day. I'm just looking at what would be information that would be helpful to narrow down the job descriptions and also to help me in the trial.
Okay, I understand that, but on the legal issue, is the court in agreement or disagreement with our position that you have to go through all the same before you get to the similar?
No, I think that would be correct, that you would go through all the same before you get to similar, but
And then I understand the discovery issues that could result as far as similar.
right. So I mean, meaning like if you've got banquet server, let's say you've got 6 banquet servers positions, right? And then you've got for the plaintiff's example, like, 15 banquet servers that were laid off. So you fill the positions for the 6, and then the similar would be offered to either the banquet servers or whoever else is similarly situated for that other position that is now open.
Yes, that's.
Okay, all right, so that's my understanding of the statute, so I hope that helps. Okay, all right. Okay, so then is that, oh, and then we've got the issue regarding the internal transfers. So this is a little bit trickier because we've got the labor commissioner's guidance, which I have to tell you, I don't necessarily agree with. Because it's not what is in the language of the statute. And I'm not really sure how they came up with that. Because when I was looking at it, hang on. Okay, so this was from the preliminary guidance on Senate Bill 386 effective July 1st, 2021. And subsection 7. So the statute itself reads March 12th, 2020. Anyone that was laid off prior or that was working before March 12th, 2020, and then was laid off because of the COVID shutdown and all that kind of stuff was considered the laid off employee. And in subsection 7, they then make this determination that an employee currently employed at a covered enterprise that was employed prior to July 1st, 2021 has priority over a laid off employee. That's not what the statute says. And I get it that, as a business, you are relying on the labor commissioner to give you guidance, but, and then, I was looking also to see what deference do I give to the labor commissioner? And it appears that, the court defers when the commissioner's interpretation is reasonable and consistent with the statutory framework. And it aligns with the legislative intent and does not conflict with statutory provisions. This is under Laborers International Union of North American Local Union 169 versus Office of Labor Commissioner 131 Nevada 1309. I don't know that their interpretation of that aligns with AB 386. So I'll certainly hear argument on that issue, and I realize that puts the covered entities in a terrible position, because they are also relying on guidance from the labor commissioner. But in looking at the statute and their determination, we've got this gap between March 12th, 2020 and July 1st, 2021. And I'm not really sure where they came up with this. So
First, I agree that it does put the employer in a bad position.
a full position,
Because
right?
Employer has a right to rely on the labor commissioner and, whatever the merits of the labor commissioner's position. Clearly, the statute said you can file a claim with the labor commissioner if you think SB 386 is violated. So certainly they have some role to play in this.
Right. Well, and it looks like there's dual ways, right? You can either file it with the court or with the labor commissioner.
And it is a terrible position because the outrageous penalty provisions, the $500 a day, have no good faith exception. We relied on the law, the labor commissioner. I mean, so but putting that whole thing aside, the way I look at the issue, the court is correct that if you took the language of that particular section of the guidance and on one side of a table and you put on the other side of the table the statute, I agree that you can't say, okay, here's all these words in the statute that,
right.
I mean, I agree with that, but what I would say, Your Honor, is the implications of this here are essentially that it's talked about in the brief that not only did SB 386 say we're not going to, during the SB 386 period, approximately 14 months, we're not going to worry about performance criteria. You can only hire people who'd worked at the covered entities. So if you laid off, we had 4 different properties and never reopened, you can't even consider those employees. That's kind of unfair and ridiculous. But now with this interpretation, you're saying, oh, and the employees that were hired earlier and were put in their positions before SB 386 became affected, those people for this approximately 14-month period were just, frozen out completely from any transfer promotional opportunities until all these quote unquote laid off employees got put in positions, and only then, which will probably never be reached with, so they're in limbo for 14 months. And I would argue, Your Honor, that if the statute intended to have that result, it should say that in the statute. And so the way I look at the guidance is interpreting or providing guidance, if you will, to the employers on an issue that's not addressed in the statute. And, there's just nothing in, SB 386 is about bringing people back to work. It's not to, say that, existing employers, promotional and transfer and other opportunities are just, we don't care about them for 14 months. And so I think what the labor commissioners do is filling a hole that, providing guidance on something that the statute just didn't deal with.
So I guess here's my question. Because you're asking me to look to the statute as far as interpreting what it means. And if I were to just look at the statute, just the statute itself, I think it says something different than what the labor commissioner says.
But
With that in mind, I guess my question is, even if I interpret the statute the way the statute reads, how does the labor commissioner's guidance play in as far as any defenses you may have?
well, we raised as an affirmative or general defense, whatever it would fall into, that we had a right to
Good faith
rely
reliance.
on labor commissioner guidance. SB 386 is about recalling people, honoring employees' right to return their former positions. There's nothing in that that suggests it's supposed to deal with this situation of existing employees can't, move
Promote
into
or
other positions
transfer.
for 14 months.
And again, this is another terrible situation. But if I'm looking at just the statutory language itself, I don't know if I necessarily agree with the labor commissioner. However, it seems like that would be something that the covered entities could bring as a defense regarding that. So I would be inclined to just be looking at just the plain language of the statute, but then allow, obviously, the covered entities to look to the labor commissioner's guidance as a defense to any transfer decisions that they made, because it's very messy otherwise. So yes, was there something that you wanted to say?
Yes, Your Honor, I fully agree with you that the statute is quite clear that it says each available position should be offered to a laid off employee, which is defined within SB 386. We agree also that the labor commissioner's opinion does not warrant deference, as we briefed in this matter. And defendants did not blindly rely on the labor commissioner's advice. The labor commissioner also said in paragraph 8 of its preliminary guidance that the covered enterprises should be offering only positions with comparable number of hours. So if there was a full-time position, that should have been offered first to a full-time employee. Defendants throughout their actions very openly stated that they weren't going to do so, that they would call a on-call person or a part-time person if they had a greater length of seniority and not look to whether it's full-time. Now, that shows that the defendants were not by any means blindly relying on what the labor commissioner is saying. They're picking and choosing. So we would be happy to litigate the reliance at a later date. We agree with your reading of the statute.
Okay.
Thank you.
All right. All right. So then Is that all the issues?
That's it.
Oh, okay, all
Five
right,
issues.
so, and I know that this is like a terrible, horrible position for, to be looking at a brand new statute, that's just for a temporary period and trying to navigate the whole situation. Are there any of the discovery, subjects that I haven't talked about or that you need a little bit more guidance on before you actually meet and confer and then file an actual discovery motion?
I'm not sure that there are.
I can't think of anything off the top of my head. No,
Okay.
Your Honor. I
All
think this
right.
is very helpful.
Okay, all right, so, who would like to prepare the order?
We can draft it.
Okay, all right, great.
Obviously run it by Ms. Webb.
And then, let me ask, are we still on target for our trial date?
I think we're going to have to review where we are after
Okay,
this.
that's fine.
And see.
Well, a lot of it's gonna depend on how much more discovery is gonna
Okay,
need to happen.
and then are we still thinking 50 to 70 bench trial days?
I certainly hope not, Your Honor. I'm
Okay.
hoping that we will get the information as you suggested, that will help us decide who, and figure out some of these claims before trial.
Okay,
Yeah, I mean, I assume we're gonna file summary judgment motions against most of the plaintiffs based on pure seniority arguments, but that's another issue down the road.
okay. And then I didn't even, hold on, when are we set for trial?
Actually, is that left open?
Oh, 2027. Oh, okay, all right, so we still have some time. Okay, all right. Are there any other housekeeping matters that need to be addressed on this issue?
Is there a firm trial date? I thought we just held it in advance till after this hearing.
Oh, so so there's not a firm, I mean, so the way that bench trials work, usually you guys get filled in the spots after the jury trials, and because this is a bench trial, I have the flexibility, for example, going into my criminal stack, if there are no criminal cases that get set, as long as you have witnesses that are readily available. So what I would anticipate is we would start and then just, continue. There might be some days without
That's fine.
trial, just filling in. So that's kind of what I would be looking at, just to let you know. Mostly I'm Mondays and Fridays I'm usually open all day, and then Tuesday, Wednesday, Thursday, we would be going from about 10:30 or 11 till 5. But since it is a bench trial, we don't have to think about a jury. It gives a little bit more flexibility.
Whatever happens, Your Honor, I don't think we'll have you here for 50 days.
You do or you don't?
I don't.
Oh, okay.
We appreciate the flexibility on that, Your Honor. I
Okay.
mean, these are going to be mini trials, so I think
Sure.
the format will.
Well, and then I also think, we may need to, in a conference, talk about if there are certain plaintiffs that have like similar claims, right? Maybe do those all in a row and then, like however we want to organize it, so it is the easiest for me to digest and retain that information. That would be really helpful.
It definitely needs to be broken down into components.
Yeah, I think so. I mean, because it really has to do with the types of claims and things like that. So I will rely on you to meet and confer first about that issue, and then I can also schedule a conference where we can discuss that as well. Are there any other housekeeping matters?
Not that I can think of, yeah.
Okay, all right, great, thank you.
Thank you for
All
all your
right,
time today.
okay, have a good day.